friends, after hearing Mr. Gargi, we know what is happening in this country. We know rightly, as he says, it is no rule of law. That's absolutely, if there is I think a proper genuine survey is made, I think the police will have to answer a major charge against them that they are the worst breakers of law in this country. And it is happening repeatedly, and unfortunately nothing is happening through the judiciary. That's the unfortunate part of it. Before I come to that subject, I'll tell briefly about Arun Ferreira. I know Arun's mummy is here. I know Arun's sister, Chandra, they're all living opposite to my house in Bangalore. 39 years they were there. Today, of course, I have shifted on Mary. They are still in Bangalore. And when I came to know he was arrested 4 years ago, I was shocked that how could he be arrested for what? And then, of course, arrested case after cases. I remember some 2 years ago they came to me again, told me he has been acquitted in 4 cases. Can we apply to the High Court? Because earlier bail application would not be given. Can we apply to the High Court? Citing that he says, look, all his cases are identical. I will acquitted. That the High Court should consider. I advise them, you file a writ petition now or a bail application now, saying, look here, similar cases are being filed one after the other. In all cases I have been acquitted. Now I should be given bail. But unfortunately, I say, the High Court didn't accept that. And he continued. All 8 cases are over. And now, of course, suddenly he knows, he says, it is happening all over Vidarbha. It could be happening all over the country. We don't know what is happening. I remember years ago, I had been to Hyderabad, and there you must have heard of a poet, a revolutionary poet by the name of Varahara Rao. And he was fighting for the tribal people and so on. And every time he came on the stage, or he wanted to say, or he wanted to, the police would arrest him under 151. We have one provision in the Criminal Procedure Code, 151 CRPC. I wrote an article some years ago, which appeared in the Midday, to say that is worse than Tada. Because in Tada there is some kind of check is there. Under 151, there is nothing like that. You have to, the police officer has to say, look at your face, I think you are likely to commit an offense. That's what he thinks. And you are arrested. And you are arrested, no question, and you can be kept in the police station for 24 hours without any charge, nothing. And then you want to continue, then of course you have to go to the magistrate. Most of the police, what they do is, you are taken there, kept in the police station for 23.59 minutes, and then you are released. So that charge is over. After 2 minutes they get the arrest. And they get 151. Never produced before the court, never, and no chance. I remember once I went to Hyderabad for a meeting, myself and Kannabiran were proceeding, and there was another car following us for a public meeting like this only, and another car, some journalists, lawyers were in the other car, and we went, some of them, we had to go to a place called Karim Nagar, supposed to be at that time very people, small group, PWG, they were all acting there and so on. We were going there to address the meeting. And the car, there was 144 there, 144, 145. And I don't know, we could manage to go inside, but the car behind us didn't come at all. And we went there, we waited for some time, we had the meeting, but still they were not seen. Then I went to the collector was not there. I went to the superintendent of police, he was not there, but somebody was there in the office. He said, sir, we don't know anything about it. So at 5 o'clock the meeting got over, we were on our way back, and these people were coming from another side. And what was that? They were all arrested, detained somewhere, and taken from there, taken to some police station, and they were all charged at 151. At the end of it, by the evening, as the meeting got over, they were released. And what could we do? So this Varahara Rao wanted to file a writ petition, because he was arrested 13 times like that. And he was filed a writ petition. But the High Court said, okay, by the time he comes to the High Court, the case is not there. And therefore, the court said, well, there's nothing against you now, and therefore, petition was dismissed. So the court didn't see today a common man, must in Bombay city, you raise a voice, you protest, Police come, arrest and take you to the police station. You ask them under what law? Very often they don't know under what law. Paratal Police Act 110, that may be, but very often they don't know. You are arrested there. If you ask, then they will say make a note in the diary and 151 CRPC. In the evening you are let off. That's what happened to them. So the police can today put down a poor man, a man who resists can put down. Just because your desire to protecting the government, you can be set down by using 151 CRPC. Years ago I remember telling that in this country, police became corrupt through prohibition. Prohibition law came and the police became corrupt. And much later, the Tada law came and the police became autocrats. Under the old law, prohibition law, you have to just say, you are found with a bottle of liquor, bottle of water, wherever it is. They can come and keep one bottle inside your house, and they come and say, you got a bottle here, and people have been arrested. Large number of people have been arrested like that. Because they can always do, if somebody has to be thrown out from the house, the master has to only arrange with the police, put one bottle of liquor there, ask the police to raid, the man is arrested, and okay, take this kind of thing. So police became corrupt. And we had heard that those days, the Home Minister at that time, I think it was some Varahara Rao, he was the Home Minister, and the rumor was, and that was, I would believe that he was to auction NPS to the police officer. If you want a particular police officer to call, you want an NPS section, give so much money to him or to people. And then of course, he would get that police station for a period of 3 years. Then the police would transfer somewhere else. The next man would come. This is the kind of thing. This is the kind of administration that we have. When we brought the Constitution in 1950, soon thereafter, A.K. Gopalan was arrested under MISA, Internal Security. Those days, they would only say you are a communist. That's enough. You are, the moment you are told you are a communist or you are a communist, you are likely behind bars under Major Internal Security Act. Because being a communist was such a dangerous thing at that time. Of course, America did that, and therefore we of course easily followed that. And of course, this was challenged in the court of law. And we have a provision, Article 21, right to life and liberty. The law says your liberty cannot be taken away except in accordance with the procedure established by law. Which means your liberty has to be taken away, there should be a law, whatever be the law. There should be procedure, whatever be the procedure. Procedure may be good, bad or otherwise. Anything, law may be good, irrational law, no, nothing of the kind. That is the British due process of law. In Britain, that is the law. That if an officer is done in accordance with the law, then you can't question that. That's the kind of thing. But the American due process was totally different, because now we didn't accept that. And when A.K. Gopalan's case came to the Supreme Court, argument related to human rights was advanced. Principle of natural justice were advanced. All other things were argued, but Supreme Court said nothing doing. Supreme Court said that 1952 case, reported case, Gopalan's case. What the Supreme Court said was that we are not concerned with human rights. We are not concerned with the other. We look into the Constitution. Article 21 says only this. Here is the law. Here is the procedure. You are arrested. That ends the matter. This law held good for nearly 25 years. Some 25, 26 years. And then came the Maneka Gandhi's case. Maneka Gandhi's case where for the Supreme Court, for the first time, elaborated the concept of life and liberty. They said life doesn't mean mere limbs and soul. Life includes everything that goes with life. Liberty doesn't mean that just according to law. The law has to be just. Law has to be fair. Law has to be reasonable. Procedure also has to be just, fair, reasonable. And the law is unjust, they will strike down the law. This is the time. But so today, after 78, we all should have expected there is more regard for due process in this country. But unfortunately today, the concept of due process is being diluted to such an extent today, you find more and more, for example, benign sin. What ground was he arrested? Nothing. What the procedure they followed? Nothing. What was the trial? With the bogus trial, that kind of thing. And yet, of course, nothing could be done. went to the court. How many times? High Court would not give, lower court would bail, Supreme Court would not give bail initially. Finally, the court, one day, the judge had, one of the Supreme Court judges, didn't even wait for the garment, didn't even wish to notice, straight away release on bail. That was accepted. Again, when he was convicted, what happened? Again, the court would not question it. It's simple. Can this man, the question is one of liberty. The court do not look at that way. Now, this is because we have brought in laws like TADA, laws like quota, which gives powers to the police to do whatever they like. The power to confess. That's how torture became routine in this country, all over the country. Torture goes on in every police station, not an exception. And torture is nothing but inflicting pain for the purpose of getting information. Today we have been demanding that there should be a law related to torture, that the international covenant against torture, and yet of course we have signed everything, but we are not bringing a law related to torture. So the police think they can do with impunity. Whatever they do, nobody can question. This is exactly what's happening, and one of the reasons is today the courts are made to believe that security of the country, in the name of security, anyone can be detained. You go to the Supreme Court even today, any other issue of human rights, perhaps you can argue, we have to listen to you. The moment the government says, sir, it's a matter of security, you are shot. Then security means all things. TADA was upheld. No, you haven't got to Manakaga in this case, that the TADA law could never have been upheld because it contained all violations of human rights provisions. It contained all things that have been laid down earlier with a power to confess, which is contrary to our whole criminal jurisprudence in this country. Yet we said confession, okay, confession need not be done by a police officer, but if a hierarchy officer does, that confession should be looked into. Bail, of course, cannot be given. That was not the law. So all these things were brought, and that was upheld because confession of security. Armed Forces Special Powers Act. You see what happened in Manipur, I had gone and seen what happened in Manipur. I went there some 6-7 years ago. Sharmila, even now, on a hunger strike, nobody bothers about that. And now for a few days, they become a big national issue. Sharmila has been demanding abolition, removal of arms, not the army. She says, remove this act, which gives special power to the police. You go to Manipur today, Imphal, capital, I've gone there. The last film show is at 4:30 because people have to be inside the house before sunset. Because after sunset, you are safe, the police can shoot and nobody can question. When we met the local, there was a session judge who was earlier a local metropolitan magistrate. He was the chief metropolitan magistrate. Army had taken him and tortured him for 3 days. The chief metropolitan magistrate of Impala was tortured for 3 days. And the charge was, the army said, you have hidden a Naga tribal man in your house. He said, I have nothing to do with that. They would not listen to him. After 3 days, they gave him shocks and he fell down unconscious. And then, of course, they left him and went away. Now, when he got up, he went straight to the High Court. In his old shirt, dress and everything, the wherever he was. He walked into the court and said, Lord, I am the city chief metropolitan magistrate and this is my condition. And the judges were shocked. They appointed a district judge to conduct an inquiry. Inquiry was conducted. The officers who committed this were identified. The names were given. A report was made. But what happened? Nothing happened. These facts were brought to the notice of the Supreme Court when the challenge to the Armed Forces Special Powers Act was challenged in the Supreme Court. All these things were put on affidavit, given to the court. That what happened? They upheld the law. Only the Supreme Court said, told the army, you do this, and don't do this. And when I went there, I brought a report, they were doing the exact opposite. That do's are there, they were not doing, that don'ts were there, they were doing this kind of thing going on. This is exactly what is going on in this country today. It's a very sad thing, I feel. You see, concept of bail, for example, is slowly, I'm not bothered about cases that we are talking about, but I'm referring to concept of bail. There is an excellent judgment of Justice Krishnaya. Bail versus jail. The rule is bail and not jail. Bail is not a concept to keep a man behind bars. Bail is a question of liberty. The question is before the court is how much his liberty should be curtailed. Not that how much time he should be kept inside. The court does exact opposite role today. You at a moment you say, sir, he charged a heavy case, he charged a murder case, he charged a big scam, put him behind bars. That is not the law. That is not the law. Question is, how much his liberty could be curtailed. It could be curtailed. Today, I tell you, not only all over the country, after this Justice Krishnaya judgment, even in murder cases we are given bail. Because cases do not come up for hearing for years together. Question is, should we keep them inside for such a long time? And therefore, test is, what would he do? The history of the accused. Has the accused indulged in such acts when he was let on bail? That's the test. They don't bother to do. They don't bother at all. They would only say, sir, he is a dreaded Maoist or a dreaded Naxalite. That's, these two words, no proof, no evidence, nothing of the kind. And then, of course, he kept behind bars. We have brought Tada law. Over 73,000 persons were arrested under Tada law. And I tell you, when Tada was abolished in 1995, out of that, about 70,000 persons were free because there was no case against him. But all those persons were inside the jail. All those persons were without a trial, were kept inside. And this is a kind of law that we have done. And that's why we have said this is against human rights, against fundamental rights, against constitutional liberty and so on. Nothing the court would not understand. All those people came out after so many years. Did anyone bother about them? Did anyone pay compensation to them? Their life is gone. This kind of approach. And finally, I think 3,000 person case went on. How many were convicted at the end of it? The conviction under Tada was 1.8%. That's all. So that today, this is a kind of law that we bring. This is a kind of administration that we have. We talk of liberty, rule of law, democracy, everything. But police do whatever they like in this country. And that's the sad part of it. And in a country where we have such excellent judgment like Manekana's case, due process, and the very other earlier judgment, can a magistrate or a section judge deny bail in a case like Arun Farida? When he was charged with the 9th case, which was registered sometime in 2007, he is inside from 2004. He's inside 2007. This case was registered after he was inside, and your record was shown in absconding, where throughout 4 years and 4 months he was inside the jail, and you say the record is safe. All these things were brought to the notice of the magistrate. Yet the magistrate or the session judge says he can't give bail. But how do you think like that? You see, when Vinay Sen was convicted and the appeal was filed in the High Court, I can't understand what is the charge against him. What has he done? The court is no bail. No bail. How do you say no bail? You see, this is the kind of thing. Ultimately, the person had to go to Supreme Court, and fortunately he came before a bench which could understand, and then of course you granted him bail. It's a kind of approach. I don't know this. I wish the judiciary is stronger. Sanjeev Bhatt, for example, his affidavit is the Supreme Court. He has already challenged the case that has been filed against him. He is arrested, brought before, he was a police officer. There is no presumption that he could have committed the offence or he had committed the offence in the past. Nothing of the kind. On a charge that he imposed a constable driver to sign an affidavit, he has been denied bail. Not only that, he has denied bail. The police want to take him to their custody for the purpose of questioning. What questioning? You could have questioned the court itself. You want to ask what kind of questioning? And look at the attitude of the judge. I don't know when the bill is coming again, but I was shocked to say, judge says you have to go to the police station for 3 hours, and then I'll give you bail. How do you say for 3 hours, 3 minutes you can't even take? The man's liberty has been taken away unjustly, maybe a minute, maybe an hour, maybe a day. You can't keep him behind bars. That's the principle judges who should follow, and that's the principle we all followed in the past. And today is unfortunate, and very unfortunate. Liberty has no meaning. Liberty is only now, practically the police allow you, okay, the liberty. They find some books in your house. I may have all those books in my house. The police raid and say, oh, you are a Marxist. So what? I'm a Marxist. But then you are arrested, you are taken, and you are charged. And what the charge? And then one moment you say you are Naxalite, no bail. How can this be? This can't be. And I think the press, the media, unfortunately, the media should focus it more and more. Media should tell what is going on is not good for the country. If Naxalites have come in those areas, whatever they do, they are entitled to their ideology. If they are really acts of violence, to the extent you can catch them, but to the extent you can't catch them, you can't say that you will have general operation, surround everyone who wants to raise and so on. This cannot be done. This is a basic thing. I think we all are gathered here to protest against unjust arrest of Mr. Arun Pereira, and I think press should highlight that.